What's up, everybody? And welcome back into this wild world of YouTube. It's a little bit more of Inception today, as two of our ladies we've covered in the past have crossed paths here. And so many of you sent me this video. I saw it pop up on my YouTube recommended videos. I didn't click it. I don't know why. I just was like, oh, that's interesting. It's kind of funny that she's commenting on this case. I don't know why she is. I don't know if it's something she's planning on doing in the future. It'd be kind of cool to see, a judge comment on cases, especially in the state she was a judge so recently, and especially with clients writing letters to judges and complaining about judges and getting new judges. And what I'm talking about here is the Parkland judge, Shearer, former judge, is commenting on Sarah Boone's case on Court TV. I have no idea what she says. I have not watched it, like I said, but just way too many of you sent it to me for me to ignore it. And we've watched Camille Vasquez and Ben Chu comment on other cases, so why not former Judge Shearer? All right, let's get to it.
This morning, we're shining a spotlight on the suitcase murder trial involving defendant Sarah Boone. She's accused of second-degree murder after she zipped her boyfriend up in a suitcase and left him there to suffocate and die, according to police back in 2020. Well, now, 4 years later, Boone is impatiently awaiting her trial and maintaining her innocence. She's gone through a carousel of attorneys. She's currently on lawyer number 8 right now, if you can believe it. And she's also penned numerous letters to her former and current judge on the case, voicing all of her frustrations. To her new judge, the Honorable Judge Kranick, she writes, quote, "Finally, a new judge. It's
If you guys are interested, we did a breakdown on her new lawyer and her new judge in our prior video on the Sarah Boone playlist. And if you want a quick recap and summary, that gives you a little more details than that. We did a 1-minute just snapshot on it on our YouTube page if you want to check that out.
strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge for 4 years, and me still incarcerated with nothing to show other than seven different attorneys, not by choice.
And it's funny that she says that she was trying to recuse the former judge. There was really no reason she had to recuse him, but it was a rotation. And again, those are the questions I would ask Judge Shearer.
I'm still wondering why I've had to wait for 4 years for something to finally happen on or in my anticipated. Do Sarah Boone's communications tell us about her? We have a very special guest. We're so pleased to have on opening statements this morning. She's a civil attorney and she's a former Broward County Circuit Court judge. You know her from presiding over the Parkland school shooting case, the Honorable Elizabeth Shearer. Good morning, Judge. Nice to see you today.
Good morning. It's great to see you too. Great to be here.
Oh, thank you kindly. Let's talk first about all of the lawyers that Sarah Boone has gone through, Judge. She has just managed to get her 8th lawyer representing her. I know you've gone through some of the documents ahead of coming on the show this morning. Based on what you've seen in the withdrawals that have been filed with the court by all other 7 lawyers, what are your thoughts on how difficult she might be?
All 7 lawyers withdrew the same way, and they weren't all withdrawals. Some of them had conflicts. Some of them were out right before they started. We went through all of them in another video where we saw exactly how each one went out, and not all of them withdrew for irreconcilable differences like the last couple have, but regardless.
The client, Judge?
My gut reaction is she does not like the advice that her attorneys are giving her. My gut reaction says that there's a pattern here. These lawyers are obviously she's obviously coming up with some type of defense or some type of trial strategy that her lawyers believe to be either against her interests, not in her best interest, or just a flat out fraud on the court. In other words, something that's completely false, and they do not feel comfortable going forward representing this woman, knowing that that's the route she wants to take. That's my gut reaction when I read it. Although attorneys they're not required to tell you exactly what happened because of attorney-client privilege, but when they use words like irreconcilable differences and due to ethical considerations, which were the words that were cited in the last motion to withdraw, that's sort of a judge read between the lines type thing. She wants me to do something that I can't do under the rules of professional responsibility.
Yeah.
So again, and I think that's an absolute hit it right on the head with Mr. Hobson. Some of the prior ones, I don't think there was that. I think Sarah Boone had some legitimate complaints about some of the prior attorneys, and I think some of the prior attorneys had legitimate conflicts to where they couldn't represent her. So, the pattern of her being an annoying client, no doubt. The pattern of her wanting more from her lawyers than they're willing to give, no doubt. I'm not so sure we have this pattern of her asking her lawyers to commit fraud on the court or things like that. I don't feel comfortable saying that. I feel comfortable saying that with Mr. Hobson, that she was asking him to do something he did not feel comfortable doing, or he did not feel was the right thing to do, ethical, maybe lie. We can insert certain things there with Mr. Hobson for sure. But I also think that if we remember back to her prior attorney that withdrew and was allowed to leave the case, that she also wanted off the case. Part of why he wanted off the case is because she was mean to him, basically, and belittling him and demeaning him publicly, which is all wrong on her part, and she shouldn't have done that. She should voice her concerns with the court respectfully. She was not respectful to the attorney, so their relationship broke down over the time and lack of communication. So there was a lot of other things going on with that. And again, as you move back further with her attorneys, there are other issues in the public defender's office and with conflicts, like I said. So I don't want to put it all on there. I know it's easy to pile on a criminal defendant, easy to point the finger at her, but I want to just try to make sure we keep the facts as appropriate as we can and as unbiased as we can, even though she is clearly a very frustrating person. It will be a very hard and difficult client to have, no doubt about that.
Yes, Judge Scheer, thank you for that. We use the term in the legal world, the noisy withdrawal, right? Where attorneys want to signal something to a judge like yourself to let you know, look, we're doing everything, right? Everything we can. It's not us, right? So Judge, thank you for that. Moving on to something else. Sarah Boone likes to write letters to the judges. I'm sure during your time serving on the bench, you've received some jail mail yourself. What's it like when that happens, and how do you manage that, please?
So believe it or not, the majority of the jail mail, the judge doesn't read, because it's actually an ex parte communication, meaning it's one party talking to you without the other party present. In other words, if the prosecutor was writing the judge letters without copying the defense, you can see how problematic that would be. So as a judge,
I just had to pause that right there. I agree.
you have to just do a cursory review of what is it that they're asking for. If they're asking to fire their lawyer, or they're indicating that they want a speedy trial, those are the only two times you can actually acknowledge their request. Anything else has to be copied and sent to the lawyers for both sides in order for it to be comply with the ethical rules of having both sides review everything.
Right. Judge, thank you for that. Sarah Boone, currently on attorney number 8. Based on the past history, it may not work out so well. I'm wondering, let's just say you're the judge presiding over this case. How might you manage it if there's a problem with attorney number 8? Then at what point, I guess what I want to ask, at what point might there be a suggestion, or can there even be a suggestion to Sarah Boone to perhaps consider representing herself?
Well, in my opinion, as a judge, the last thing that you want is somebody who's difficult to represent themselves, because that makes the job so much harder on everybody else. And it really, very rarely do you see a case where a defendant can represent themselves and be effective.
Agree, 100%. I didn't know where she was going to go with it, because again, we haven't watched this, but she just made a great point. Everybody who thinks it's so unfair, Sarah Boone's getting all these lawyers, taxpayer dollars, we're paying for her to have a defense. At this point, just make her do it herself. Well, just so you know, the court system is not just doing this for Sarah Boone. They're also doing it for themselves and for the court system, because it is so much worse for a judge if Sarah Boone represents herself than lawyer number 11, 12, or 13. They'd rather have a lawyer in there representing her, number one. Number two, as long as this trial gets done and we get it to resolution, we don't have to do it again, potentially. That saves a lot of taxpayer dollars. And if she represents herself, that could open up a lot of appellate issues and a lot of other issues throughout the trial going on. A mistrial, again, that could create issues where we spend a lot more time and money, and it's more miserable on anybody or on everybody involved. So It's not just appointing these lawyers for Sarah Boone, but for everybody else involved as well. Because Judge Shearer makes a great point that it's much worse on the judge to have a very difficult client representing themselves, and it can be very difficult to be effective for that client.
So that would not be my goal. However, without criticizing any particular judge, I would say this boils down to case management. And my practice was, let's say attorney A wants to withdraw and attorney B wants to come in. I bring both attorneys forward before me and I say, why do you want to withdraw and why do you want to come in? And then I make them tell me exactly what else needs to be done on the case. I give them a reasonable amount of time and I tell attorney B, I'll let you in on this case, but you're going to have, let's say they ask for 6 months. Okay, 6 months, not a problem. I'm going to set the trial 6 months out, but you need to be prepared. If you can't be prepared, tell me now, and I won't let you in on this case. She'll have to find somebody else or stick with the previous lawyer.
And again, with private lawyers, I think that works well. With court-appointed lawyers, I'm not so sure that it works exactly the same as that, as lawyers wanting to come in and she has to choose somebody else if you're not able to do it in that time period. I'm not so sure that works the same with court-appointed lawyers. Private lawyers, sure, we do stuff like this all the time.
That would be so that it wouldn't get to attorney number 8.
Right. Appreciate it, Judge. Judge, hearkening upon your experience as a prosecuting attorney, we know that you served as a prosecutor early in your career. I want to show you 2 clips now, please, and get your reaction on the other side. And the first one, this is going to be key evidence, the video of the victim inside the suitcase crying out for help. And then in the following clip, you'll see Sarah Boone speaking to investigators who arrive at the scene after the 911 call.
Sarah.
The problem is I fell asleep. When did you do CPR? This morning, when I found it. Before you called? Yes. 1 o'clock right now. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, oh, he's in the suitcase still.
So she passes out or falls asleep while he's in the suitcase. Judge, your reaction to this case evidence, as we know this stuff, it's coming on in.
And it's compelling as anything. I mean, that's some of the most compelling evidence I've ever seen. I mean, you could almost feel yourself gasping for breath as you're watching it. And that leads me to another, although, of course, this is my opinion and I can't say for sure, but a woman who's trying everything, going through attorneys like this, even though she's saying, I want my day in trial, my gut reaction is she's trying to delay and delay and delay because she probably realizes just how bad the evidence is against her.
See, that I completely respectfully disagree. I do not think that she is trying to delay this case. I think she could have delayed this case with Mr. Benkowitz. That's the guy's name I forgot before. She could have delayed this case with him. So all he was doing was delaying the case. She could have let it go, and then pushed him off the case later. You guys let me know in the comments. This is good. 2 lawyers disagreeing, Judge Shearer, myself. I don't think she wants to delay this case. I think she wants it tried the way she wants it tried. I think she wants to present the defense she wants to present. And maybe lawyers are like, you don't have that defense, or that would be a fraud on the court, so we can't do it. I think that's the issue. I think she does want to get this case tried. I don't think she wants to delay it. I don't see how delaying it really helps her personally here. Now, if she gets convicted, she gets convicted. She could still potentially get out one day if she is convicted, but I haven't felt through the process that she's trying to delay. We've seen it in other cases where it does feel like they're trying to delay. I don't feel that here. She does in her gut. You guys let me know. What do you think?
In this case.
Right, Judge. I've got another clip where she's talking to police and they talk about notifying the victim's next of kin. Take a listen to what she says when they tell her that.
They're going to know what we're here, what we're investigating, and that they're going to think I killed him.
Why would they think that?
They always have said that. They've always have said that.
What have they
I
said?
told you it's because I'm the blue-eyed white dragon. That's what they call me. Because they don't want him with me.
So he's basically just not really been around his family because he chooses me over them.
Judge, what do you think hearing her say that?
This is someone who, as a criminal defendant, is not smart. By the way that she's coming at the media, she's trying to
This is someone who's a criminal defendant who's not smart. That's what she started with. It's like, oof, just a little savage start.
to give her side of the story. I imagine that was her setup of what she was going to eventually tell the police, and she's trying to come up with excuses, not realizing that all of this talking is just hurting her. She is stepping one foot and then another foot and one step after another into a deep water.
Oh yeah.
She's just not doing well for herself.
No.
Which is why you don't talk to police. I'm not really sure what she meant by like a step into deep water. Maybe she struggles with one-liners similar to myself. But yeah, I mean, she kept putting her foot in her mouth right after the next and saying things that can and will be used against her. But we talked about it in the beginning. We broke down all those videos, all of her conversations with cops about how she thought, like many defendants do, that she can explain away what happened. She can explain to the cops why this all happened and why it's not her fault and why she didn't do anything wrong. So many criminal defendants do that, and so many of those statements are later used against them in court.
Oh, not at all. I can't wait to see if she testifies at trial. I have a feeling she might. Judge, last question. Do you think we'll see it?
Go ahead.
Oh, yeah. Do you think we'll see her testify?
I absolutely think she's going to testify. I think that's the other problem. I think that her lawyers can't get her not to testify. And ultimately, that's the defendant's.
I don't like that. I don't like that. Okay. That's definitely not a reason to withdraw. It's definitely not irreconcilable differences. It's definitely not a reason you should bounce off of a case if the defendant wants to testify and you don't want them to testify. It's fine if you tell them the risks, and as long as they don't lie, that you know they're lying or commit fraud on the court, it's their right. It's their life. It's their case. It's their trial. It's your job as a lawyer. So if they want to testify, you heard it in the Murdaugh case. I think it's very clear his lawyers did not want him to testify. He wanted to testify. What did they do? Well, they advised him against it. They tried to get him not to. They probably had him sign something that said this is against counsel's advice. And then he testified because it's his case. It's his life. If he thinks he needs to go fight for it on the stand, or Sarah Boone thinks she needs to go fight for it on the stand, then let him. While not knowingly, of course, committing fraud on the court. But I could never see myself or our firm withdrawing from a case because a defendant wanted to testify. Advising against it, sure, it's happened many times. Sometimes they listen, sometimes they don't. But I don't see that as a reason to bounce off a case personally.
Right. So what I predict is going to happen is a lawyer cannot suborn perjury, knowingly put forth perjury to the court. So these lawyers obviously...
Meaning they can't ask her questions they know she's going to lie to as part of her defense. And I do agree with her there. But again, you don't have to withdraw if that happens. Especially if you're a court-appointed lawyer or public defender. I've seen them do this before. And you let her get up on the stand and you tell the court, I'm not in a position ethically where I can ask Ms. Boone any questions. So instead, she is just going to give a narrative from the witness stand and just let her talk. The judge knows what's going on. Sarah Boone can take her own risks if she wants. The state can cross-examine her. And it's just a different way to do the trial. It's not, I don't think that's the reason for these withdrawals. I think it's something else.
We are having differences of opinion as to whether she can testify. They don't want her to testify, if I had to guess. I imagine they will sort of submit her testimony to the court without asking any questions in the form of a narrative, which is the only way that a lawyer legally, under the rules of professional responsibility, can offer testimony or allow their client to offer testimony without being a part of it, knowing it to be false.
Right.
It's funny. She's right. And I didn't know she was going to say that, but we agreed on that. I thought that was going somewhere else. I thought she was going to say, like, they just don't want to be her lawyer because she wants to testify, which is kind of what she was saying. But then she not fixed it, but she kind of added context to the end. If they do, and they do put her on, it has to be a narrative. So we're on the same page there, Judge.
Hey, Judge, this is such fascinating insight you're sharing. We really appreciate that. It gives something for us to look for when the time comes, because reading between the lines, kind of reading the tea leaves in all of those motions, it seems that there is a big problem going on here. And maybe you just might have hit the nail on the head with her testimony. We've got to leave it there for now, but we would love to have you back. Judge Elizabeth Scheer, thank you so much for coming on Opening Statement.
Okay, that was cool. Okay, that was interesting. So again, that's why a lot of you sent it to me, probably to get my take on it, get a little recap, a little reaction like we do to a judge from one case commenting on another case, both of whom we have been following here on the channel. So it's always cool when that happens. Like I said, the wild world of YouTube, a little bit of YouTube inception sometimes it feels like. But thank you guys for continuing to send me the content. It's been kind of a crazy week, weird week. I'm kind of glad it's coming to an end and ready to start fresh next week. We will see what is upon us. Let me know what content you want to hear. Let me know what you're interested in. If you subscribe to the channel, you get to help pick the content and the cases we talk about. So make sure you hit that like button. Let me know what you thought. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.